Thank you very much. I really appreciate that, and I'm really glad to be here today. Last 4 days this week, at this time in the morning, I was sitting in federal courthouse in Austin, Texas, and on the other side, just as Dr. Huntoon described, was a whole array of attorneys on behalf of the Texas Medical Board. And we had a federal trial all through this week that just wrapped up yesterday. And I want to give you a personal account of how that transpired, and I'm going to spend about half my talk on that issue, and then I'll take questions on that issue, and then I'm going to move to some other topics that I know are likewise of concern to everybody in this group, which includes hospitals and peer review and also the ObamaCare litigation. But let me focus first on our federal trial that just concluded against the Texas Medical Board. 8.5 days ago, I was in Austin in federal court in the judge's chambers with a whole array of attorneys on the other side. And he looked at us, and he looked at our case, and of course the Texas Medical Board has been trying to dismiss our case against him. As far as I know, there has never in the history of the United States been a lawsuit like ours which brought a state medical board to trial for its misconduct. So this is an unprecedented action. And he looked at it, he looked at the arguments by the other side, he turned to us and he said, "We're going to trial Monday morning." That was Wednesday afternoon in Austin. So 2 business days left. He said, "We're going to trial Monday morning." And that's a busy court. I don't fault the judge at all for saying that, and I was happy to have that opportunity. So I welcome that. But that's short time to get a federal case together. And I had to fly back to the East Coast. I had to get my exhibits together. These are the exhibits I prepared, and you can look at them during a break. I had to start to line up witnesses, had to get subpoenas out for witnesses. That's a lot to do in just 2 business days. And then, of course, get all my stuff together and travel back to Houston, and then drive up to Austin. On a personal side, my wife at the time had a very bad cold, one of the worst I've ever seen her have, and she kept saying, "You're going to catch this cold. There's no way you're not going to catch this cold. Just take the vaporizer, pack it, because you're going to get this thing." And doctors in the room maybe can explain this, but I never caught the cold. And in fact, I had a sore on my foot that was slow in healing. I'd had it for a number of months. Sometimes there'd be pus, and it was very uncomfortable. And I looked at my foot this morning, and it all healed. Physicians can tell me how that happened. So Monday morning at 10 a.m., just as the judge said, he came out, and actually a few minutes before, as we were sitting there, and just as Dr. Huntoon said, there's a whole array of attorneys on the other side. There are 5 attorneys at the desk at the other side. And people in the courtroom started to pile in on our side of the courtroom. And it was pretty nice to see all these supporters of AAPS come out of the woodwork to attend that trial on such short notice. Doctors who had patients scheduled that day, they cleared their schedule, and they came down to watch. And that was real good to see that. And there was Jules' husband came in there, and he's an Olympic gold medalist, and that was nice to see him. Another doctor, not only did he come down, but he brought his whole staff down. And they piled in the courtroom, and there weren't too many people on the side of the Texas Medical Board in that courtroom. And one of the attorneys came over to me, seeing all these people coming to the courtroom in the gallery, and just so you know, the attorneys notice who's in the courtroom, and the judge notices who's in the courtroom. So it helps just to show up and watch. That gives a boost to the attorneys. That's something that is taken notice of by everybody. And we always had people on our side there in the courtroom, and gave me a new appreciation for AAPS, the way that people will drop everything on short notice and come and stand up for the principles that we are defending. So that was remarkable. The attorney on the other side came over to me and said that she was going to invoke the rule. And every federal court's a little different. They have a little different terminology. And I'm thinking to myself, invoke the rule? What's she talking about? And I thought to myself, no, we're invoking the rule. It's called the U.S. Constitution. We're invoking the rule. Well, the rule she was talking about was to get an order from the judge to clear all the potential witnesses out of the courtroom. And a party has a right to do that. I objected to it, but they cleared all the potential witnesses. But we had many people there who were not witnesses. So while they were able to clear some people out of the courtroom, there were many people who stayed who were not going to be witnesses in the case. The three violations of the Constitution that we have been alleging in this case are, number one, violation by the Texas Medical Board of the Equal Protection Clause. And that is the way that the board has been manipulating complaints against certain people for certain wrongful reasons, such as a member of the board forwarding allegations to the board, which are then manipulated against her competitor for her competitive advantage, such as insurance companies filing complaints with the board, and then that complaint is processed by someone who is receiving compensation from someone in the insurance industry, maybe not the same insurance company. And when he went on the stand, he tried to argue that no, he was not receiving consulting compensation from that specific insurance company. He was receiving compensation from consulting with another insurance company. Well, I explained to the court that's a pretty fine distinction to make, okay? And I asked him in cross-examination, I said, did you disclose to Dr. Ray, some of you know Dr. Bill Ray, who was subjected to complaints initiated by Oxford Insurance Company because they didn't like having to pay the bills for the care that he was providing to the patients. And by the way, Dr. Ray in general did not send the bills to the insurance company. The patients wanted the care, the patients paid for it. The patients would then send in reimbursement under their insurance policy, and the insurance company then filed a complaint with the medical board because they didn't want to pay these bills. And I asked the witness, who was a top disciplinarian on the board at the time, and I said, did you disclose to Dr. Ray that you were receiving compensation by a company in the insurance industry when you presided over his case? And he said, no, he didn't. And I said, did you disclose it to anybody? In fact, here's your public disclosure form. Do you show on your public disclosure form that you were receiving compensation from a company in the insurance industry? And he looked through it, and he said, no. And then I said, in fact, didn't I have to go to federal court to get a federal judge to order you to divulge whether you were receiving compensation and how much you were receiving from an insurance company? He said, yeah, I guess you did. Well, that is part of our second claim of constitutional violations, because that's a violation of due process when there's an undisclosed conflict of interest by a governmental entity that has the power to take away your medical license. If you go into federal court, there are all sorts of disclosure requirements for the judges, and there are all sorts of disclosure requirements in other walks of life, school boards and so on. If you have a medical board in your state, as there is in Texas, where there are no meaningful disclosure requirements that require the disclosure of that information, then you don't even know about the conflict of interest, so you don't even have the information you need to object to it. And they made the point in Texas at this trial, they said, look, if a doctor feels there's a conflict of interest, he can object and ask for the recusal of the board member who has a conflict of interest, and usually that recusal will be granted. Well, that's of no use when you don't have the information on which to identify the conflict of interest in order to object. When there are all these undisclosed conflicts of interest, you don't know. You don't know who's making money from an insurance company while they preside over your conflict with what may be another insurance company, but it's part of the same industry. So that's our second allegation of constitutional violation. And then our third one is the retaliation that the Texas Medical Board does. And I had several examples of that, where they retaliate against people who speak out against them or people who file suit. And it was courageous of the witnesses who did come down to Texas. Some were there, some have left the state. And they stood up and they testified against the Texas Medical Board, knowing how retaliatory that board is. And it was quite an experience for me to see some of the witnesses obviously uncomfortable in court and had not done this before and obviously terrified to be up on the stand to answer my questions. They were nervous at first, and then I would turn them over for cross-examination by the medical board, and to see the witness get stronger during the cross-examination to the point where by the end of the cross-examination, the witness had completely defeated the Texas Medical Board on the point at stake. That was tremendous to see that. We battled for 3.5 days there with the witnesses. That particular court uses a clock, which I have never seen used before. It's not used in most other jurisdictions. But they have a chess clock right there on the clerk's desk. And the judge said at the outset of the trial, each side gets 8 hours. And that includes your examination time, your cross-examination time, your rebuttal time, 8 hours, and that's it. And then you're out of time. And so when I would stand up, I would call my witness and start to cross-examine my witness. My clock was running. And then when I would sit down, the other side would do the cross-examination, their clock was running. And that, at first, I thought, that seems like a difficult constraint to deal with. But as the trial progressed, I really started to like it. It really played in the strategy. And if you can manage your time, it became very effective for our side. And I made sure that I used up as much of that time as possible, and I used more than 7 hours. And the judge, at one point, he turned to me and said, "You're not leaving enough time left for your rebuttal case." But I said, "That's okay, Your Honor. I know what I'm doing here. And I'm going to use all my time and almost all my time in presenting my case." And I was thinking to myself, because the Texas Medical Board is not going to have much of a case to put on. And so I'm going to use more than 7 hours in presenting our case in chief, the witnesses such as Dr. Bill Ray, who flew over from Dallas on a moment's notice and rescheduled his patients. And I had many other AAPS witnesses who did likewise. And we put them on, and I chewed up almost all my time, and then I handed the case over to the Texas Medical Board, and they had very little case to put on. They had very, very little in the way of evidence. Instead, what they did was they stood up, and this would be Wednesday afternoon, and they stood up and they moved the judge for a directed verdict. And they said, "Your Honor, we've had the plaintiff's case in chief. We do not feel that they have proven constitutional violations here, so we're going to ask Your Honor to rule in our favor at this time." And they had a fully prepared motion to do this, and they argued at length to the judge. And then it came my opportunity to rebut it, which I had to think of on the fly there. And I stood up and I started rebutting it. And I started to use some of the state's testimony against them. I mean, I had our witness testimony, but I started to put the pieces together. And I'm not sure that they realized this when I was eliciting their testimony during the trial, but I started to use their own words against them. And one of the things that the Texas Medical Board kept saying was, we're complying with state law. We're processing these complaints, we're making the disclosures, we're conducting our business exactly the way state law requires us to do. And I said, that's fine, that's fine. I'm challenging the constitutionality of those state laws as they're applied by the Texas Medical Board. I don't care whether they're complying with the law or not. It's their conduct that's unconstitutional. And if that's in compliance with the state law, then all the more reason for this court to intervene and strike down those laws as applied. So I really was able to turn their arguments that we're just doing what we're told, what we have to and stuff, against them and say, that's the problem, Your Honor, because you know what? They're going to keep doing it that way. They're going to keep doing it that way. They're going to keep violating constitutional rights. And if they're making the financial disclosures that the state requires them to do and it's not enough, then this court needs to intervene and say those disclosures are not enough because people are not seeing who's getting paid by insurance companies and how much. And if they're allowing these confidential complaints to be processed against competitors for competitive advantage, that's unconstitutional. And if the state law requires that confidentiality, we need to strike down the state law. And the judge listened to my arguments. I had a number of hypotheticals that I elicited during the testimony, during my cross-examination of the Texas Medical Board, and some of them I think may have caught the court's attention. One of them, for example, was I said to the Medical Board's witness, I said, the way you process these confidential complaints, suppose you got a complaint on letterhead that was the Democratic Underground. That was right on the letterhead of the complaint. You got a letter on stationery of the Democratic Underground. And what the complaint said was that they feel that there was improper care rendered to Mitt Romney by Dr. So-and-so in the state of Texas. And we think the medical board should investigate. Would you process that complaint? And would you then retrieve all the medical records relating to Mitt Romney and have that sent up to the medical board? So those medical records are all over the medical board and then could be leaked to the press, the personal medical records about Mitt Romney? And the answer was, that's what the law requires us to do. Yes, we would. And then the witness said, well, you know, we would certainly not leak that to the press, you know. And then I tried another question. Suppose you got a complaint that just had racist words all over it, all over the complaint. They're racist, you know, slurs against the doctor. Would you process that complaint confidentially just as though it were a legitimate complaint? Yes, we would. Yes, we would. And I think that was chilling, that's the way that they're applying the law, that's the way they interpret it. As I say, it doesn't matter to me whether the state law requires that or not. That leads to a constitutional violation. All right, the protecting that confidentiality and processing those complaints is so open to abuse. Now, much of the abuse of the trial concerned one doctor filing complaints or having complaints processed for competitive advantage. And I can't tell you how many times during that trial I had to define what a competitor is. Basic words. They were constantly objecting. It would be like I'm standing at the podium here examining my witness, and I would say something like, well, was this member of the board competing with this other doctor? And I would get a chorus of objections by all these attorneys who were sitting to my left. Objection, what does competition mean? Who's a competitor? What's it mean to compete? Till finally, at one point I said to Your Honor, I've defined the word compete 3 or 4 times during this trial. Everybody knows what it means, and I've defined it anyway, and they're still objecting to it. And they said, well, he's defined it, but he defined it while that witness was out of the room. Now he's got to define it again for this witness. The judge got tired of those objections after a while. He said, listen, I know what these words mean. You know what these words mean. The witness knows what these words mean. Let's get an answer to the question. And as the trial, as the trial progressed, they got less and less successful with their objections. And the judge sustained more and more of my objections. And you could really see the tenor shift as the trial progressed, which was wonderful. Bad faith was another word that they objected to. I would say, would you process a bad faith complaint? Is a question of the Texas Medical Board. Oh, objection, what does bad faith mean? The judge got tired of that too. He's like, I know what bad faith means, you know what bad faith means. Answer the question. We got a lot of good evidence in there, a lot of great stuff on record. We completed, the Wednesday afternoon, they presented their motion for a directed verdict. I then argued in rebuttal. The judge considered it, and he said, motion denied. Motion denied. After he denied that motion, the Texas Medical Board then had the opportunity to put on their own witnesses. And they had a number of members of the Texas Medical Board there at the courtroom, sitting outside. People recognized them. But they chickened out. The board chickened out for some reason that I don't know for sure. There's a lot of strategy in a trial. It's a fascinating thing. I know we have some attorneys with us. A federal trial, any trial, but particularly federal trial is a fascinating game of strategy. And I don't know why they chickened out on calling those 3 witnesses from the medical board, but they did. And they never called their own people who were sitting outside there to defend what the medical board has been doing. They did call their executive director, but she had already been on the stand. I had already examined her. And she did call another person who I had also examined at length. But they did not call any of the new individuals who had not been introduced at the trial yet, who were people responsible for the day-to-day operations at the medical board. And there are 2 possible reasons for that. One is, and another play of strategy, earlier in the case, I tried to introduce a witness whom I had just learned about fairly recently, who left the medical board this year. And because I learned about her recently, she was not on the witness list, and she would ordinarily not be allowed to testify. But I tried anyway. And I had her there at court, and I called her up to the witness stand, and she was an employee of the medical board who had left the medical board this year. And the other side went ballistic. And they said, oh no, objection, objection, objection. And the judge kept her out at that point. But you can always bring in a witness at any time for impeachment purposes. And if the board had put on their staff members, then I would have been able to bring this witness back and have her impeach the testimony of the board staff members. So they knew she was there, and they did not want to open the door for me to bring this witness back and contradict everything they said. And I also think the board did not want to subject their staff to my cross-examination, where I would start to ask them a lot of questions about what's really going on at the board. As a result, the Texas Medical Board put on almost no case for themselves. And they rested at that point. I still had a little bit of time for my rebuttal, but in a show of strength, I said I won't use my remaining 45 minutes, I'll rest my case too. And then the other side moved again for a directed verdict. They really don't like our case, and that is unusual to move twice. And again, the judge said, nope, I'm not going to grant your directed verdict at this time. This is what I'm going to do. And what he then ruled shows you how strong he thinks our case is he established a briefing schedule, which is a little unusual, but he said, I'm going to give you time to brief these issues thoroughly, and I'm going to call you all back for oral argument after I've had a chance to read your briefs, so we can have oral argument that pulls this whole case together. And he scheduled that for early next year so that there's plenty of time for him to sort through all the facts here and the law. And with that, the final decision will await our final oral argument in it, but I can tell you the Texas Medical Board was very unhappy when we left that courtroom with this result. So on that topic, I'd like to open it up for questions about this case before we move on to some other issues. Howard.
Do you believe that the precedent of this case in Texas will carry over to California, Arizona, Ohio, and other state medical boards, particularly on the question of the constitutionality of their own rules?
Absolutely. This Texas case, yes. Howard asked if this precedent in Texas will carry over to the other states, and the answer is absolutely. Texas is the leader in some of the behind-the-scenes programs of medical boards. The Federation of State Medical Boards is located in Texas, and that is a well-funded organization that pushes out some of these bad anti-doctor ideas into medical boards all around the country. That's located right in Texas. Texas is also a big state. I mean, 10% of the practicing doctors in this country practice in Texas. Every other medical board is aware of this case. And the possibility that a medical board and the officials who are making these decisions about doctors will have to stand trial in federal court to explain themselves, as the Texas Medical Board just had to do this week, is a profound message to send to all 50 state medical boards. Another question about the case.
Well, I'd just like to say again how brilliant you are and how much we appreciate it. Usually the government tries to find some face-saving way to sort of wind things out of the court and settle or change policy or directives. Is there anything they can do? Nothing.
No, there's nothing they can do. They cannot settle this case. I mean, I would welcome settlement offers. You know, I'd welcome to say we're going to change, for the medical board to say they're going to change their ways. You know, welcome, let's talk about that. But they're not used to doing that. I mean, just the process has changed that board from a bullying board that terrorized everybody in Texas, the physicians, patients, and so on, into a board that has to explain itself and is facing the possibility of a federal judge holding that they have been acting in an unconstitutional manner and that they need to be restrained from violating constitutional rights. That is such a huge power shift. And at one point during the trial, the judge, as it was clear, he was getting it. I mean, he was clearly understanding what the evidence was saying. And he turned to me and said, look, what you're really complaining about here is abuse of power, right? Next question. Great, from a law student in the back. Very good.
My question is, once a state or some sort of government agency steps in to help regulate the boards, then how can local physicians help maintain control and lobby to a government now who's regulating the practice in a different way? I don't think the problem is entirely solved when power just goes from a medical board to a government agency, where probably the strongest lobbying group could be the local faction of the AMA or a similar entity. So certainly, even a successful case would not necessarily heal everything. But do you see I guess the question is, do you see better opportunities for people in this room at the state lobbying level or the regulatory level there against the medical board, or do you see perhaps just a second come from the same team, the same entirety?
We're not asking for another regulatory body. We're not asking for oversight by anybody else. We're asking for some clear restraints on abuse of power by the medical board. And there are state laws that can be passed to do this. There are good laws that state legislatures can enact. And I've just realized, just coming out here, the term good law is a bit of an oxymoron, isn't it? Yeah.
Yeah. In New Jersey, having been subject to abuse of the medical board, they actually, one of the board members called me up to apologize, which is rather unusual. My concern is all these hidden sources of income for the medical board. And how do you go about exposing that when we don't really have a means to? I found out about my board, how corrupt it was from other sources after the case. How do we go about finding out about these unethical kickbacks, financial arrangements?
That's a big part of our case. Those should be disclosed. And if there is so much hidden conflicts going on, that can be unconstitutional in itself. And that's what I presented to the court. And the other side didn't have an answer to it because the medical board is saying, we're complying with state law in what we disclose. That doesn't resolve it. And I explained that to the judge. You know, the judge, at one point, he said, well, wait a minute, the witness has said he did all he was required to do under state law. And I explained, that may not be good enough. I mean, suppose the state law said that it's okay to take $1 million on the side from an insurance company while you're disciplining a doctor as a conflict with the insurance company. That doesn't make it constitutional. And so we're suing to get a declaration that certain hidden conflicts of interest can rise to an unconstitutional level.
That's sort of what I was asking. What are you seeking from the judge? What sort of penalties would he mete out?
I'm seeking a restraining order and a declaration that this is unconstitutional. So it's like the situation where your neighbor keeps coming over and harassing you, and this is a lot worse than just a neighbor harassing you. You go to court and you get a restraining order to stop the harassment. I compared it to profiling during one of my arguments. I said, look, Your Honor, this is like if the Austin City Police started stopping every black driver who came into the city. Okay, that's unconstitutional, and it's not enough just to fire the police officer who was doing it. There's something systemic that's allowing that to happen, and that's got to be stopped. And I pointed out that when I went up to the Fifth Circuit in this case and won a decision in this same litigation from the Fifth Circuit Court of Appeals, the Fifth Circuit judges emphasized that the Equal Protection Clause is about more than race. It protects against racial discrimination, but there are other types of discrimination it protects against too, such as the unequal treatment by government for some nefarious purpose. Yes.
Are you aware of a case, Dactors Data versus Stephen Barrett?
Yeah.
Okay, I just wanted you to be aware of it.
I am aware of it. It's a little off topic, so we can talk about that another time.
And my question was, the defendant physician inappropriately reported to the National Practitioner Data Bank, and if so, were you able to get it revoked or erased?
None of this case involves reports to the National Practitioner Data Bank. I'll get to that in the next segment of my talk with respect to hospitals. Yes.
Yeah, I was going to ask, is there any attempt to require state medical boards to file disclosures of conflict of interest? I mean, I'm up in Ohio. I just got an email from the state attorney there. I asked them specifically, what are the conflicts of interest disclosed by 2 members of the board? And there is no disclosure. Should that not be part of our attack?
It should. It is. It's part of this case, and it should be part of legislative attempts as well. Go ahead.
Yes, my name is Rehan. First of all, I want to congratulate Mr. Shafley for such a big task of taking the Texas Medical Board. Indeed, this is, I think this should be a sign for all the medical boards to watch for the constitutional rights. And we are dealing with a similar situation with California Medical Board. My wife, she completed residency from University of California, and she is never licensed to practice in the state of California. And one of the issues you raise is the unconstitutionality of the laws. We are raising the same issue. And I am wondering if there is a process which will protect all physicians. For example, I attended ACLU had a campaign a few months ago, and their campaign, they went through a bus tour, and their campaign was stop unconstitutional laws against immigrants or illegal immigrants. And eventually, they turned down the unconstitutional immigration laws in Arizona.
Okay, we're a little short on time, but I see your point.
Let me quickly say that. Is it possible for physicians to organize and go to organizations such as United States Department of Justice to watch all the laws that all the medical boards are putting, and have an institution help physicians to go through the process?
We do have that institution, and it's called the Association of American Physicians and Surgeons. See it right here. I guarantee you that no other organization is going to help in these cases. It's right here in this room, and it's the network of physicians. It's finding a pattern. And let me just, before Richard speaks, I just want to say the key to this case is the pattern. Because if it were just one physician who sued, this case would have been dismissed a long time ago. They would say, okay, this one doctor has a gripe, and then the medical board will start to make all these allegations about the physician, and the court will say, look, I don't know, we're not experts in medicine here, forget, I'm not going to get involved. But as an association, we were able to put together a pattern, and that's what makes it a powerful case.
Andy, congratulations on a great piece of work. I think my theory as to why the medical board didn't put up their witnesses is that they don't particularly like it when the other side is wielding the colonoscope. It's a different...
That is very true. And the witnesses I put on for the board, I could see in their demeanor as I started to question what they were doing. I could see a lack of comfort in being on the hot seat and having their conduct questioned and examined for a change. Okay, let me move on to the next topic. Hospitals. Just in the last year, there has been a big uptick in a problem that has existed for 10 or 20 years. But it's been an uptick recently in hospitals interfering with the practice of medicine and destroying good physicians and basically trying to take over the medical profession. And part of this is due to Obamacare, which seems to encourage hospitals to consolidate and to get control of the physicians on their staff. And what they're doing is they're squeezing out the independent physicians. This is going on nationwide. This is not limited to Texas. It's going on everywhere. We see it in every state. And hospitals are getting smarter, and it's nonprofit hospitals, or shrewder, I should say, in how to acquire other hospitals and how to drive independent physicians off of staff. And I'm confident that there are many doctors in this room who have seen this happen to themselves or to their colleagues. Don't feel like you're the only one. Don't feel like there's something wrong with your practice. There isn't. They get trained in how to do this. These hospital executives at nonprofit institutions that are taking millions of dollars in personal compensation out of nonprofit institutions are getting trained in how to destroy and eliminate independent physicians. And we're developing tactics to oppose this, and we're involved in a number of court cases on this. And I can tell you personally, as I litigate in a variety of different fields, hospital attorneys are the worst attorneys that I have ever encountered. Common courtesies that every other attorney would immediately grant: an extension of time, consent to file a friend of the court brief. Hospital attorneys never grant them. And I guess it's that problem where eventually an attorney starts to mold into the personality of his client. Like if you see, right, if you see attorneys who represent clients in organized crime, after a while the attorney himself starts to act like someone who's organized crime and starts be bullying everybody. Well, these hospital attorneys, they have molded into the personality of their client, never consent. And so I ran into this just in the last few weeks, a case that's going up to the Fourth Circuit. Hospital retaliated against a physician who spoke out against some of the hospital executives. He did it internally. He didn't embarrass them publicly, but he did it internally about the way the hospital executives were starting to interfere with patient care. They came down hard on that physician, and they destroyed him, and they eliminated him from the hospital. In fact, they excluded him from coming to the hospital even as a patient. And then he got fired by his own pathology group. It went into litigation. Now it's going up to the Fourth Circuit. This is a longtime AAPS member. I said, yeah, we're going to help you. You know, you're part of AAPS. This is the problem we're talking about. We're going to come in and file a friend of the court brief, which we do with increasing frequency. And courts take notice of that. When we come in with a friend of the court brief, and we've been put right in the decision sometimes. We're going to file it. I asked them for consent. Hospital attorney said, no, we're not consenting. Absolutely not. I said, fine. I'll file a motion with the court. I filed a motion with the court. And then I got the feedback from the court, the Fourth Circuit Court of Appeals, Monday morning, just as I was going to trial for this Texas case. I got an email from the court about my motion and my brief, and I'm thinking, oh no, they can't be telling me to change it a little bit or file papers or something. I just can't do it. I got this trial down in Texas. No, I opened the email, and what it was the court ordering the hospital to respond to our friend of the court brief. Let's go to questions on this issue. Yeah.
Prior to the 1970s, the hospitals did not have attorneys regarding their bylaws. And I have noticed in my own experience that beginning in the 1970s, when the number of administrators blossomed from 10% to 3,000% over that decade, and number of the physicians only increased by maybe 100%. I have actually a slide on that. I think when the attorneys got into the hospital administration and writing their bylaws, all of these problems became major nightmares for a lot of doctors. And like in your case with the State Board of Texas, are they hiding behind confidentiality issues? What exactly did the board do that was so egregious? And is this cloak of confidentiality a big impediment to you prosecuting a case?
Yes, the cloak of confidentiality is a big problem that both medical boards and hospitals use. And they use it not to protect the doctor, they use it to conceal their own wrongdoing. So we are hard at work to speak out to the extent we can, and hospitals don't like that. In fact, I ran into one hospital where one of our members was having an issue, and they're eliminating their independent physicians, and I started talking to them and sending them emails, and they tried to bully me, these hospital attorneys, and they said, you can't speak out like that. You know, you better watch what you say. You know, you better watch your back. And I said, excuse me, you know, you are a public nonprofit institution. You are accountable to the public. You have nonprofit status. You have an obligation to serve the public good. And they didn't like that, but they shut right up.
How much is this generated by JCO, where JCO is imposing more rules and regulations on hospitals? For example, to become re-credentialed at a hospital, usually you just had to send in a form and you had to list like 3 references and that was it. And then JCO then began saying, well, we want some cases, some consults or whatever that you have to send in to the medical staff office also, showing your activity and the quality of your work and whatever. I mean, that was something very new, and that was something that I think that JCO was sort of dumped on the hospital. So JCO adding more rules and regulations and forcing hospitals sort of do this and that as far as physician oversight and credentialing.
I don't think so. I understand what you're saying, but honestly, from where I stand and as I watch this, JCO is really a tool of the hospitals, where the hospitals will say, oh, JCO is requiring us to do this, JCO is requiring this, but behind the scenes, the hospitals are really getting JCO to impose requirements that are more profitable to the hospital executives. So JCO is weak and ineffective, and I don't waste any time complaining to JCO. But I do tell state legislators, and I testified at a state legislative hearing, and I said to the committee chairman, I said, have you taken a look at how much these nonprofit hospital executives are taking in compensation for themselves? Millions of dollars? Does that seem right to you? And it was Democrat, and he said, no, I don't think that's right. He didn't put it quite in those words, but he said he was concerned about it. And I just heard from a member in attendance here that same legislator is now going to call for hearings on the compensation that these hospital executives are pulling out of these nonprofit hospitals. So.
Well, one thing I've noticed is that if you check who's the executive director of professional physicians organizations, bylaws, the boards, it's always a lawyer. It's always a lawyer telling doctors what to do. How many bar associations have a doctor, executive director? I'm sure the argument would be that, things are complicated, you need a lawyer, but if they're that complicated, then they need to be less complicated.
That's a good point. Now, let me tell you something about sham peer review that I did for one of our members. And this was after our interim meeting in New Jersey, and I said I was going to do this. He got a sham peer review. We got a summary suspension by one of these bad nonprofit hospitals, completely baseless. Summary suspension. Summary suspension is supposed to be if there's an emergency need to intervene and prevent the surgeon from going into the operating room when he's intoxicated, for example. And Illinois passed a law, in fact, to say hospitals in Illinois are prohibited from imposing summary suspension unless there is an urgent need and justification for doing so. But there's no such law in most states, and in Jersey, they summarily suspend them. You got to act quickly. And within about 10 days of that summary suspension, I had a lawsuit filed in federal court, and you got to do some of this stuff in federal court, because in some states, in state court, you just don't get enough independence from the hospitals and the medical board. So you got to be in federal court for some of this stuff. And I filed a complaint and moved for that federal judge to enjoin the hospital against reporting that summary suspension to the National Practitioner Data Bank. Almost unprecedented. And that federal court held an emergency hearing on that issue, and the hospital was there, and they were complaining and whining, and this is inappropriate, you shouldn't be doing this. But that federal judge issued an order restraining and prohibiting that hospital from reporting that summary suspension to the National Practitioner Data Bank. It was a huge win. And if you're looking at that, let me know. But just remember, you got to move right away. We get too many cases where I hear the summary suspension was a year ago. You got to move in days of a summary suspension or something like this to get in federal court to stop the report to the National Practitioner Data Bank before it happens. Yeah, Craig.
On hospital conflicts of interest, in my latest article in Medical Economics, the title is pretty much explains it, Why Do Hospitals Compete with Us? It seems that hospitals are buying cardio practices, surgical practices, even some family practices, and they're competing and marginalizing private physicians to the side and kind of having them atrophy off staff. What can be done about this in pointing out the conflict of interest here?
We got to have state legislative hearings. We got to have legislatures look at this, call hearings on it. We got to expose it. We may be able to sue on it. We're exploring ways to sue some of these nonprofit entities for the breach of their public trust. We'll take one more question on this topic, then I want to address Obamacare quickly.
Are there any movements in place to repeal the Health Quality Improvement Act? From everything that's in the language of it, it seems to be the fuel for the abuse of hospitals against physicians. Are there any measures in government that can look to appeal the ridiculous HQIA?
There is a provision that's been introduced in Congress which would repeal part of the HQIA and prohibit hospitals from reporting to the National Practitioner Data Bank until after their internal peer review is completed. So that is a provision in Congress that you might want to get behind and support. Let me say something about Obamacare. The decision by the Supreme Court, 5-4, was on one type of challenge to Obamacare. But we have our own lawsuit that's challenging Obamacare, and we filed it quickly after Obamacare became law, and it's been in the court system. It was on hold while everyone waited for the Supreme Court decision. But we have a challenge to Obamacare in our case that the states did not have in their case that was narrowly decided by the Supreme Court. And in our case, we challenge Obamacare under the Fifth Amendment that it's an unconstitutional taking from one private citizen to another private citizen, which is prohibited by the Takings Clause of the Fifth Amendment for the government to order each of us to buy insurance from a private insurance company, which is essentially ordering us to, as private citizens, to give some of our money to other private entities, insurance companies. That should be addressed independently from all the other challenges. And it doesn't matter whether the Obamacare is valid under the Commerce Clause or other provisions of congressional power if it violates the Fifth Amendment prohibition on taking from one citizen to give to another. You're not allowed to do that. Government is not allowed to order one person to give money directly to another person. And I just got word this week that the federal judge in D.C., which is where we're located, has taken an interest in our argument. And just this week, she has issued an order commanding the Department of Justice to respond to this argument that we have made against Obamacare. Okay, thank you very much.